What's up? What's up? What's up? What's up? What's up? What's happening? Oh yeah. How do? How do? What's up? You know we doing it again. Let's rocking the birthday gift. They should know who bought this. Oh man. Time for some more glasses. These showing keep slipping, sliding. My head too big, running too much. So we gonna go straight to the gate. You know what I'm saying? We're gonna go straight to the gate in that, in reference to the fact of what happened at the 40 Rector experience. When I say that, we're gonna go into because this one's going dead. All right, so I'm gonna have to do it straight from the head. A girl went dead. Well, what is it about is the case law. And how you get case law, it goes into burden of proof. See, they have to have a burden of proof. And then the key thing is that if you're in civil court, in that it's a burden of proof, but it falls under a preponderance of evidence. Okay? So in criminal court, it's beyond a reasonable doubt in the whole nine. See, in their situation, it would go to criminal court in their matters because the simple fact it's beyond a reasonable doubt based on factual evidence. The actual evidence that what they use, you use that against them. So that would bring in beyond a reasonable doubt. But in a civil matter, it's a preponderance of evidence. So basically, it's what's stacked against you. Like, if it's 51%, you know, they got you. Or, you know, that's what they try to do. Then, like, in this situation, the judge used what he called case law. Case law. So he's like, I'm going to use the case law based on the time and attendance situation. So remember, under the time and attendance situation, this action was caused by the dirty director, which brought about the abuse of authority, the abuse of powers, violation of corporate compliance policy. Why? He's on probation. He's on probation. All right, what is that, 5.2.3? Okay, this will bring about gross misconduct. And if you look up gross misconduct under Black Law's dictionary, that tells you right off top, grounds for termination. Yes, gross misconduct in employment. When you look it up on the Black's Law dictionary, it basically says that's grounds for termination. Do your math. It's not hard. So I'm gonna go to the judge where he said, under preponderance of evidence, you know, we're gonna use this case law against you. Really? How you gonna use a case law from a prior case against the defendant and you didn't look at the true facts in the case? Because if you look at the true facts in the case by using that case law, are you saying that the other cases that you had are basically the same? Because that's what you're saying under preponderance of evidence. That's what you're saying. You're saying it's relatively the same situation. Really? So in those situations in the case law that you use against me, did they directly use their car in a threatening manner prior to any charges for time and attendance? In a reckless endangerment manner, did they violate any state or federal laws, even local laws? You know, because like the use of the vehicle in a threatening manner is under traffic law. So traffic's basically an infraction, right? That would be 1212. Reckless driving. That's an infraction. What do you call it when it kicks in under Penal Law Code 12020, which is recklessness, and which brings about using a dangerous instrument, you know, and you cause a fear of physical injury. What do you call it then? What do you call it when it brings in 2020 or 120. The first one was reckless dangerous 120-20, and then the next one is 120-15. Menacing. What do you call it when it's that? Then to go even further, what do you call it when it's 120? What's that? 45, which is stalking, because you came in and you sat there and you waited. This is the director who did this, the probationary employee who did this. So my point, my argument is, did you add that fact into your burden of proof? No, your preponderance of evidence before you use your case law, because the case law that you use is irrelevant, because the case law that you use has nothing to do with the situation that was at hand. Because you got to also add in the fact that the charges were brought about or caused by the probationary employee, which is the director, the hospital police director. Those charges was caused by him. You can't break a law or break a rule or regulation to try to enforce a rule or regulation. See, the key thing is, isn't that retaliation under their corporate compliance policy? That would be retaliation. And then for you to be a judge and say, oh, I'm going to go ahead with this and sign off on it. The mere fact that the director caused these actions would constitute improprieties, a wrongdoing, a felony, a misdemeanor, a crime. See, when it goes to the penal law code, it's a crime. Okay? This is totally hilarious. I do these videos because of the simple fact of how far they're willing to go. And anybody that's been subject to this type of nonsense need to check their documents and then go back and relate to how they use their charges against you. And then there's a good chance you were covered over certain things that they didn't want to advise you. Even if you didn't kick in the whistleblower, the Jackie Robinson still kicks in. That US 42 still kicks in if you was deprived of anything. And you got to learn what it is that you was deprived of as your right, as your privilege in the whole 9 yards, and then use that against them. That's what you got to do. So here's a judge who's an administrative law judge. He's not a judge. He's like a magistrate. He's an administrative law judge. He's an administrative law judge who's abusing his powers and authority because he's going beyond his canons. When he said, I'm going to sustain the sergeant's charge of insubordination when there was no insubordination because she failed to do what she was supposed to do as a supervisor, which is she failed to supervise. Okay? And you just said, I'm going to sustain that. Then you got the other sergeant who wrote an instrument up 2 days later who didn't follow chronological order. Meaning, technically, if that occurred, you're supposed to write it up right then and there. Officer, give me your memo book. I'm going to put this in your memo book. All right? And then we're going to go upstairs with this or whatever. But you were supposed to do it there. Didn't do it like that, right? Yeah. Sweet. Sweet. All right? Now, are we going back to that judge? Under what's that? Canons? We're going to go to canons 1 of a judge, all right? Which is your integrity. Which is your integrity. This is your integrity you messing with. And you selling out because we're in the system. They'll never know. This is our magic. You're an employee. You think you're God. You're not God. You're an employee. I'm not disrespecting you. But I dislike what it is that you did. It's people like you who taint the system. And you make the system fail because you're tainting it. So, on that note, what do your employers say? What do they say in reference to you violation of Canons 1 under your integrity and Canons 2 the mere appearance of an impropriety. How do you deal with that under the fact that you must follow the same code of judges' code of professionalism and responsibilities as a U.S. judge? You know it says, you notice I say U.S. judge, but if you acting like them, you must follow those same canons. It doesn't change. Then the mere fact that you did do this brings about, what's that? Judicial code of conduct. Under the judicial code of conduct, that will fall under, or judicial code of, that will fall under misconduct. That will fall under 487. Misconduct by counsel or an attorney. Subsection 487. Yeah, that's what that will fall under. And you will fall under that same thing. You know, it's a little different. But the key thing is the fact of what I said in the prior video, where you lose your immunity. Okay, that will fall because you deprived me of that. So when you go to that Jackie Robinson U.S. Code 42, when it comes down and it goes, except judicial officers acting within the scopes of their employment in such of an act or omission. Are we going to look past that? No, you're not going to look past that. And then you got, what's that? You got to go, unless it's a declaratory decree was violated. That would be your canons, right? See, because when you pull up the declaratory decree and all that on the Wikipedia, it comes down and you got canon law. Yeah, then it comes down to common law. So under your canons law, judges code of professionalism and responsibility. Canons law, we start with the first one, your integrity. So you're not truthful. Then we're going to go down further to, what's that? Canons 2. The mere appearance of an impropriety. Judges and lawyers are to avoid impropriety, even the mere appearance of an impropriety. Why? It falls upon your truthfulness. It falls upon your fitness as a judge, your fitness as a lawyer. It's not that hard. It's just nowhere to go and look for it. It's not that hard. So we're going right back to that case law. When these people bring up the case law against you, you need to read the case law and see, is it basically the same as yours? Because it's got to be basically the same as yours. It don't have to be exactly. See, mine's in the basically is the fact that supersedes it under impropriety. And the impropriety is the dirty director caused it. He caused the time and attendance situation. Why? A, I don't want him parking there. Violation of my right and privilege for my paid parking, right? And I don't want him parking it. On what grounds? I just don't want him parking it. Oh, so your name is now on the side of the building. I don't want him parking there. I'm the director. You're an employee. Tell me something. Do you still get that juice after they fired you? Mr. Probationary employee? Yeah, you slid for a minute. Until it got too ugly. And they said, we got to let this guy go because it's too ugly. And we're going to let you go. But 8 years later, out of that 8-year reign, how many people were affected? Wrongful termination, wrongful suspension. You had provisional people, good people, that you just got rid of on a blink of an eye. Good people. There's one officer, he's still on my page. And I know about that incident at roll call. And you went after him. What was your cause and reason for termination? That's all I need to know. Because technically, you deprived him of a right. Not just him, he's a family man. He has kids in that. You deprived him and his family of a right. What was your cause of going after him? Oh, I could just let him go. Was he there more than a year or more than 2 years? He wasn't there long enough where he gets civil service. He wasn't civil service. It's provisional. We just gonna do what we want. Not a problem. You're gonna now. Here's the ugliness. You're gonna go after him and get him out, but you was the one who violated the corporate compliance policy. You was the one who broke the laws. And you went and used your juice to wrongfully terminate him. Like I said, I wasn't the only one. You bragged about doing over 50 people, right? Yeah. No problem. You open that door up for your employers. I'm just pointing it out. Back to the matter at hand, Mr. 40 Rector. Arbitration court. Let's go there. See, the reason why I'm going there now in the whole 9 yards is because my union representative basically, when you file for your appeal as a civil servant, you have 20 days. The union rep is going to say, the union representative says you have 30 days. Why are you going to say that when you can read it and it says you have 20 days? This is so that it would go beyond that point, and then he'll sit up there and say, "Oh, I'm sorry, I gave you the wrong date, and it's too late." Yet, under Article 78, you have basically 4 months. The sweet part about this is me and one of my friends, we arguing right now, but she's a sergeant. She came there. We all passed the sergeant exam together. She came there with me to 2 Teamsters. And she sat in my Navy while I went inside. And remember the brother, God bless him, he passed. That used to be the armed security guard in the front. You got to sign in before you go upstairs. This is just before Turkey Day. So I go upstairs and allegedly he left for the day, but he knew I was coming. It was something like 2 o'clock. Like 1:30, 2 o'clock. And you left for the day? Let's be real. I don't want to see this dude because you knew you was doing your nonsense. You was in bed with them. There's the other impropriety. Now, the key thing about that is, once I brought you that document, which is the letter saying that basically their decision, you basically had 4 months under your union, all right, your employer, to file that Article 78. Because the average person can't file this Article 78. You don't know how to file it, so you need an attorney. So as the union is your representing attorneys or your paid representatives, they're supposed to file that Article 78. Under their fiduciary, they're supposed to file that Article 78. But here's this guy. He's going to work with them and be like, we're not going to file it. We're going to let them drop. Not a problem. Not a problem. That would bring up that impropriety again. That would bring up that misconduct again. That would bring up that violation of your canons again. Right? Because under your canons, it's canons 1. Under representation. I do know under that hidden 13th Amendment. Okay? Don't make me pull that up. You can find that hidden 13th Amendment in, there's a book called, what is it? Redemption 4.5. PDF it. You can download it. That's a good book for you to PDF in representation for yourself. Because as you put me in this situation, there are people that was in this situation that were incarcerated. So while they were sitting in there, they was using their minds. So like one of the guys came to me, he said, yo, he started talking about the straw man and all this and that, and he was off point. And I had to keep lining him up, get him on point. And then he told me about the book. And he had it. It's about that thick. And I was like, in separate pages and that, because he kept downloading it. I said, dude, you got a phone, right? Yeah. You can PDF it to your phone. So I PDF'd it to my phone. Like I said, that hidden part of the 13th Amendment, when it comes to lawyers in the whole 9 yards and representing you under their fiduciary, you're the last one. So the corporation, all of that comes first. You're the last one. So basically they're saying we don't give a shit about you. If you don't know. So it'd be best to learn what they do under their fiduciary. What are they obligated to do? See, this is what made me do it for that grievance coordinator who's a litigations attorney. Under his fiduciary, what was he supposed to do? Number one, U.S. Code, no. We're going to go to Judicial Code, New York's Judicial Code of Conduct, Part 1200. All right. Let's go to 3.3. Your conduct within the tribunal, which is in the court, which is in the well. How you supposed to act on truthfulness in the whole 9 yards. Was you truthful? No, because if you was truthful, you'd have told the judge right off top that the opposing attorney or the employer's attorney was using fraudulent stuff. Fraudulent evidence. All you had to do is point it out that there was the impropriety, and the judge would have threw all of that out right then and there. But you showed by your actions and try to play dumb. Remember, I had to point certain things out to you. Where the sergeant got on the stand and said, I called them at 11:55 or 12 o'clock. She sat on the stand and said she called at 11:55 or 12 o'clock. But her document said she called at 11:45. So based on the fact that you verbally said this on the stand and had to be corrected, but you stood by this on the stand, would that constitute perjury? I believe so. That would be what, 21040? Perjury? Punishable up to 3 to 5 years? You, a public servant, perjured yourself on the stand? Any questions? Come on, let's go. Let's go. Your lawyer knew you was lying. Your lawyer knew you were lying. Okay? So, would that fall under 4.1 of Part 1200, where the truthfulness of your lawyer? And it would also go under misconduct by your lawyer, because your lawyer knew what you was doing. Now, under the Teamsters lawyer, litigation attorney, who knew what was going on, he was obligated under 8.3 of Judicial Code of Conduct, or Part 1200. 8.3. You can Google this. You can Google this and download it to your phone, and then just take out your highlighting pen and highlight all that stuff. Under 8.3, he was obligated to report them. He was obligated. No, yeah, 8.3, your attorney is supposed to report their attorney. All right? If they don't do it, then they fall on the acts of 8.4, which is just judicial misconduct. And then you hit them for judicial misconduct, subsection 4.1 No, subsection 487. Misconduct by a counsel or an attorney, which is a Class A misdemeanor in the state of New York. That's how you hit it. You know what I'm saying? You want to play games? Let's go after that. Let's go after that bar card. You know what I'm saying? Get them disbarred. If you even read Redemption, you'll learn the truth about that bar card. Oh yeah. Oh yeah. Just sweet, man. Just sweet. Like I said, going back to that judge. This is how you get them from the king on down. Because the judge is the ordinary person in the court. He's the ordinary person. That's why he sits high. Do we got to bring you down from maritime law? Or amity law, which is military law? Or do we got to bring you all the way down to common law? I know we got to get you within your jurisdiction. That's the key. You must get them within their jurisdiction. In the whole 9 yards. Shred them. So they'll never do it again. But they're going to do it. It's a dirty system. They're going to do it. You got to line them up. Do your homework, line them up. Because we are unfamiliar with it in the whole 9 yards. And they malicious with it. My entire case is totally malicious. Totally. So it's best to expose them for who they are. They're probably trying to jump out right now and try to run and retire in the whole 9 yards. They want to retire. Nah. Get them before they retire or get them even after they retire. Instead of presidents where the others won't do it. See, I'd have been going hard body, but my jack went dead. I could get to the other jack. It got it in there, I think. I'm not sure. That's another thing. You got a tablet, drop down Black's Law Dictionary. Put it in your tablet, put it in your phone, put it everywhere. So you can always go back and forth to it. You can always use it. You can look it up any time of the night, any time of the day. Like I said, 24 hours a day. School is now changed. It's no longer school talking about, it's only during this time or that time. School is 24 hours a day. When you get some free time in the house or wherever you at, you take out your tablet or you take out your phone and you pull it up and you can just download anything. And then, using Word or whatever, set up your argument or set up your page or set up your facts in the whole 9 yards, copy paste it and put it over there. You could do the work. You could do in your own case. You could do a better investigation in your own case and then present it to your lawyer in the whole 9 yards. That way he can't, when he go for mediation, he can't go and try to pull okie doke. And when he goes and presents it to the opposing attorney on the side, you'd be like, they got you. What you mean? You using fraudulent stuff against them? And they went and did their own investigation, did their own homework in the whole 9 yards, and I don't think you're going to win. I think you need to throw that case out. But you must do your homework, and that starts with download your employer's corporate compliance policy. Download your signed contract agreement. Read these daily so that you'll know what you're governed for. Even download your representing unions, fiduciary, their corporate compliance under fiduciary and how they're supposed to represent you. And take that and read that along with, match that to your signed contract agreement and how they're supposed to represent you, how far they're supposed to go in the whole 9 yards and what they're supposed to do. Catch them within their boundaries so that they don't violate you. If you don't do this, if you don't invest in yourself, you're surely governed. Based on that fact, you're surely except the possibility of failure. I can speak on myself. I'm not going to speak on you. In the beginning, I did not know. That's why I took. But yet still, I never let go. Even though certain people was like, "Oh, you need to stop that. You make no sense in saying all that." Why am I getting closer? Am I getting closer? Now I got you. This is chess. It ain't checkers. I got you on your own actions. Why? Because you brought me into a court. All right? You brought me on that ship. Right? With fraudulent information. And you used it to get me, right? You do know fraud upon the ship. You do know rules of fraud upon the ship, right? The ship can't sail. If court's a ship and you bringing in fraud, what's that rule? It falls on the fraud upon the court. An instrument offered in void is fraud. And all you did was offer instruments that was in void. That was fraud. So under the substantive and substantial right of due process, which goes to the live person side, it's thrown out. It's vetoed. Once again, who governs 40 rector under the judiciary? That would be under the judicial committee, right? And they have a fraudulent case on log because it's now case law. How we deal with that? I don't know. You know the deal. The facts cannot be altered nor denied. Have a wonderful day.